not forgetting our online participants. Welcome to Unisa's World IP Day 2025 celebration. We're here today to explore the intricate relationship between music and intellectual property, how copyright protects creators, promoters, cultural development, and ensure that the people behind the music are fairly acknowledged and rewarded. Um, Before we move forward, housekeeping notes. I would like to request that we have our phones on silent. And then the bathrooms are on your left, just behind the red banner. And would like to request that if you are sharing posts on your social media platforms, please use the hashtag Unisa World IP Day, hashtag Unisa, hashtag DITTC. The Wi-Fi password is the Wi-Fi you should use the Unisa event, and then the password is Unisa at 2022 at. Then I would like to welcome our welcome note speaker, that is the Director of Innovation, Technology Transfer and Commercialization, to open our program. Mr. Noma, it will be my honor to invite you to the stage. Come.
What? Good morning, colleagues, and thank you very much, Program Director. For the opportunity. Before I even start, speaking, I want to, there's a gentleman that, I'm not putting on the spotlight, but I think you're always in our events and you're always sitting somewhere around there. Truly appreciate. Right. Good morning, ladies and gentlemen, distinguished guests, colleagues, innovators, and friends around here, and also those that are online. And I think I must mention this up front, that this is really a collaborative effort, between ourselves and the Directorate of Innovation, Tech Transfer and Commercialization, together with Chaya Mashabela, IP attorneys, as well as the College of Law and the Music Foundation here at Unisa, right? So it's one of those, initiatives where, for us, collaborating with others is one of the great important things that, we really strive to do at all times. It's both a pleasure and a privilege, to welcome you all to this important, celebration of World Intellectual Property Day. Each year, on April 26th, we join the global community in highlighting the critical role that intellectual property plays in encouraging innovation and creativity. The theme for this year, as declared by the World IP Intellectual Property Organization, is intellectual property and music, IP and music. It reminds us that IP is not just a legal mechanism, but it's a powerful tool for development, empowerment, and solving real world problems. I don't need to go to town and explain the kind of challenges that we face. And one of the challenges that we locked in currently is the sluggish economic growth. Perhaps that's how I would like to characterize it. And of course, innovation, holds the key, to actually unlocking, those the conundrum that we are in when it comes to this aspect. That's exactly what I believe in. I believe in wholeheartedly, and it impacts in the kind of work that we do, particularly within the directorate. According to the WIPO's latest data, in 2023, global patent filings under the Patent Cooperation Treaty exceeded, first time, 278,000, applications. The top 5 countries were China, the United States, Japan, South Korea, and Germany, right? And I'm sure you'll take note that the first one, right, we are part of the BRICS. It's part of the BRICS, right, formation. And of course, we are part of that BRICS formation ourselves. Answer the question in terms of, how do we then, sort of benefit from those, kind of interactions. WIPO also reported a notable growth in trademark and design applications, particularly from the emerging economies. This is something that is quite encouraging. And I always say, even with the statistics, even though we don't appear, a lot, high up in the rankings, but it does not necessarily mean that, we're not innovative. I learned this, the hard way, a few months back, when we were having a conversation. Well, it was a pleasant surprise when we were having a conversation with some colleagues, tech transfer colleagues from different countries around the continent. We convened in Kumasi, Ghana. And I'd learned about these innovations that are happening across, that are being implemented across the continent. Perhaps you may not have heard of it, but these were really quite encouraging sides. But of course, one notable insight from the WIPO report is that women accounted for just 16.5% of inventors listed in international patent application. This points to an urgent need for more inclusive innovation systems that reflect the talent of our own people, that reflect the talent, people general across the world, but also particularly so in our own context. For us here at Unisa, World IPO Day is more than a commemoration. It is a moment to reflect on how we support those who create, invent, and imagine. At Unisa, we are proud of our efforts to translate research into real-world impact through the Tech Transfer Office, the work that we do, IP Capacity Development Program, Univenture Startup Formation, initiatives, and others. I mean, innovation support programs that we have, including, some of the innovation hubs that we have, the Hub, for instance. And of course, we've made, great strides in this. Really made great strides in this. We've tried to really to be quite inclusive in our approach as a Tech Transfer Office and ensure that, as much as we mandated by another act of parliament called Intellectual Property Rights for Public Finance Research and Development Act, but we actually broad and inclusive in our approach, don't only focus on IP that comes out of Unisa's R&D activities, but also we support the students, right? Also in the creation, taking the ideas to the market and also the creation, of startup companies. We've got quite a number of startup companies that have been established, by, through, the intervention of the Tech Transfer Office, which we're really proud of those. And of course, on the 21st, by the way, but next week, I've got an R&I Research and Innovation Week at Unisa. And on Thursday, on the 21st, we'll be showcasing, some of those, startups that have been established within the university. Okay. So for us, this is something that we really take pride in. When I always tell people when we have conversations to say that if you were to ask me really, what is it that we're trying to do? We're trying to make a change in our country. We're trying to make sure that we create new competencies. We're part of those that are creating new competencies for our country, right? Creating new, sources of competence for our country. It's not a shortcut. It's not a shortcut to some of these things, but also to make sure that, creativity, innovation is consequently supported, across the board. So we must continue to build, as we believe, build a culture where ideas are protected, innovation is celebrated, and of course, creators are supported, right from the classroom, to the boardroom, from the laboratories, to the townships. Today's event is a platform for learning, for networking, and reflection. I encourage you all to participate actively, share generously, and imagine boldly. Let us work together to make intellectual property a driver of shared prosperity and sustainable futures. Thank you once again. And of course, to our speakers, our esteemed speakers, that will be introduced. We truly appreciate, holding hands with us, truly appreciate making time, for you to actually come and have these kinds of conversation. But with those words, I say welcome. We're really looking forward to the kind of conversations, stimulating conversations that we're going to have, that you'll be leading in this session today. And thank you once again. May you have a great World IP Day. Thank you, colleagues.
Thank you very much, Mr. Nama, for the warm welcome to our guests today. So today's program includes 3 fireside chats, right, with industry experts as well as academics. So transition into the first fire chat, I would like to call to the stage Dumelo Mashabela from Chaya Mashabela Attorneys to come and facilitate the first fire chat. But let me firstly introduce Dumelo. Dumelo is a dynamic patent attorney with extensive skills in various aspects of intellectual property, corporate and commercial law. Dumelo holds a degree in BSc Electrical Engineering from the University of Cape Town, an LLB degree from University of South Africa, and an LLM in Intellectual Property and Technology Law from the American University Washington College of Law. Tumelo began her career as a software engineer at a prestigious weapon company where she gained her technical experience. Following that, Dumelo qualified as the first black female patent attorney in South Africa during 2009, having worked at some of the largest IP and commercial firms in the country. With 19 years of experience in the legal profession, more than 14 years post-admission, Dumelo has a wide range of expertise in drafting contracts, developing IP strategies and policies, including conducting IP audits and due diligence investigations. With her vast knowledge and experience, Dumelo established her own IP firm, Chaya Mashabela Attorneys, in 2016. Dumelo is passionate about creating IP awareness and has done so both locally in South Africa and internationally. Dumelo has been actively participating as a guest lecturer and impacting her knowledge and expertise at the WIPO Summer School since 2012. She has also appeared on a number of media outlets such as ENCA, Newsroom Africa, and Power FM as a thought leader on various topics related to IP law. Dumelo is a fellow at the South African Institute of Intellectual Property Law and a member of Law Society of South Africa. She served as an advisory board member for the National Intellectual Property Management Office, an agency of Department of Science and Innovation. She's a former non-executive director for UJ Invent Pty Ltd and commercialization arm of the University of Johannesburg. She was an independent contractor, contracted to Unisa to develop content for an IP management postgraduate diploma. Dumelo was awarded a Professional Excellence in Innovation Management Award by the Department of Science and Innovation in collaboration with Sarima during 2018. She's currently a moderator for one of the patent board exams, an external examiner for a postgraduate course, Intellectual Property, New Technologies and Innovation at the University of Pretoria. Dumelo is an innovative entrepreneur, businesswoman, and a patent attorney who is shaping the world of IP. Let's give Dumelo a warm round of applause.
Okay, I thought I'll have an easier way out. Apparently, I need to stand. Nonetheless, good morning, everyone. And it is a pleasure to see so many of you here today, and where we are going to explore a topic that I think, it's a dangerous, but as well as an encouraging topic. So it's a topic that sits at the heart of creativity and innovation, music and copyright, protecting creativity in a digital age. Like we've heard from Mr. Noma, this is a topic that is being, given by WIPO on a yearly basis. They chose this particular topic. So we have exceptional speakers or panel of experts with us. And I have no doubt that, they're going to share insightful information, and we are going to have thought-provoking discussions. So the first, just to kick off, we're going to have, or it is actually my honor to introduce Professor Chennel from College of Law at the University of South Africa. When I came in, I asked her, how do you pronounce your surname? And then she told me, so I hope I pronounced it correctly. So Professor Geyer is has a distinguished career in intellectual property law. She's not only an expert in patents and copyright, but also a passionate educator, shaping the next generation of digital, legal minds. And today, she's going to assist us to unravel the essentials of music copyright. And she's going to help us to understand how the law actually assists us in safeguarding, artistic expressions in this evolving digital landscape. So without wasting a lot of time, I'm going to ask Prof. Geyer to come so that we can start our discussion on the basics of understanding music and copyright. It was going to be a discussion, but my understanding is that Prof has prepared, being an educator herself, she has prepared a presentation. So she will take us through the presentation that she has prepared. Welcome, Prof. Geyer.
Good morning, everybody. Just give me a moment to get this working. Can you please help me so that we can see the presentation? Oh, there it is. Thanks so much. Okay, so my task is to tell you about music copyright. So we can take a whole week to do that, but we only have like about half an hour. So one way of doing it is to share 10 things about music copyright. And I hope that by doing so, we will be able to cover a lot of ground in the little bit of time that we have without making it too academic or boring. So the first thing about copyright is that it is a form of intellectual property. So let's say you are sitting here and suddenly a song starts turning in your head. So you have this idea for the song and you don't want to lose it, so you go outside and you record it on your cell phone. So it was an idea in your brain, so it's an intellectual product that is now existing outside of you. So that recording, you can license it for somebody, for a recording artist to record it, or maybe you want to assign your copyrights in that. For that, you will need a written signed agreement. But the point is, it's not only in your mind, just in your mind. It exists independently of you, and that is what intellectual property is. So you get different types of IP. Like if it was an idea that you then went and registered a patent for, that's something different. We get trademarks, we get designs, we get plant breeders' rights, goodwill, trade secrets, all of that are intellectual property rights. But if you are working with songs, lyrics, music, sound recordings, that is protected by copyright, which is a form of IP. The second thing is that copyright is a creature of statute. So the applicable Copyright Act in South Africa is the one of 1978. It is not that it was last touched in 1978, it was updated until about 2002. And we have a copyright amendment bill that is in the pipeline. It has been for some years. And next week, that bill will be considered by the Constitutional Court. But if we don't have a Copyright Act, there's basically no copyright. So that's why we say copyright is a creature of statute. We have to keep referring back to the Act, and that is why it is so important that the Act must be right. Of course, we look to court cases, for example, to understand the Act better. If the Act says a work must be original to be copyrighted, then we will go and look at case law to understand what that means, because the Act itself does not define it. There are also some other relevant pieces of legislation, like, for example, the Intellectual Property Laws Amendment Act that was signed into law but is not enforced yet. And that act wants to protect indigenous music and other types of indigenous work, like indigenous stories, for example. So watch that space. And important to understand, if you are a performer, like a recording artist, you're a musician or a singer, then the Copyright Act is not the relevant act. There's a Performers Protection Act, and there's also a Performers Protection Amendment Bill. And that is what the performers look to see what their rights are. Thirdly, South Africa may not change our Copyright Act as we like. That is because of international law. So way back in 1886, many countries came together to form the Berne Convention, and later in 1995, we got the TRIPS agreement, the Agreement on Trade-Related Aspects of IP Rights. And these conventions have about 180 members, and the members are not individuals, it's countries. So about 180 member countries. So that is huge. So how these conventions work is the countries came together and they agreed on certain copyright principles. So, for example, they agreed on minimum standards. For example, they agreed that copyright should subsist for a minimum of 50 years calculated from a certain date. So what this means is a member country can protect copyright for longer, like some, especially developed countries, protect copyright for like 70 years, but the minimum standard is 50 years. So South Africa cannot decide, oh, okay, your computer programs are outdated after 10 years. Anyhow, so we're now going to only protect it for 10 years. The minimum standard is 50 years. The fourth thing is that copyright is territorial. I didn't plan this slide. PowerPoint came up with it by itself. So I just couldn't come over the cuteness. So copyright is territorial. So what I've now said is, that because of these international agreements, different countries' acts there's a lot of overlap. Many things are similar or the same, but there's also many differences. So if you ask ChatGPT, for example, for copyright advice, it might come up with something that is really not right because it drew on American law, for example, and not on the South African law. There was a very interesting case in 2010. The name of the case is Gallo Africa versus Sting Music. And that was about a musical known as Umoya. I hope I pronounced that correctly. Okay. So it was alleged that the plaintiffs performed and recorded and made films of Umoya in South Africa and 19 other countries without the copyright owner's permission. So what the plaintiff was asking for, the argument was, okay, court, we accept that each country has its own copyright act. England has its own act, Japan has its own act, the US has its own act. The infringement took place in those countries. So, okay, we accept we have to use the acts of those countries, but please, all the parties in this dispute are resident in South Africa. Umoya was created in South Africa. Please, can't we just take these 20 acts and in terms of them come to the South African court? It will make life much easier. And the court said, no, that's not how jurisdiction works. You have to go to each of those 20 countries in terms of the act of that country to that court. So just imagine how expensive that would be. So that's something to keep in mind. So it's territorial. The South African Parliament makes a South African Act for the Republic of South Africa. But it's also very similar to the copyright acts of other countries because so many of them are members of these international agreements. So the fifth thing is that copyright protects works. So if you go to the South African Copyright Act, there is a list of 9 types of work. So it will be music, musical works, literary works, that will cover lyrics, sound recordings, if your work is recorded. Then there are also films, broadcast, program carrying signals, computer programs. I don't know which one I missed now. But anyway, there are 9 types of work. And if something does not fall into one of those categories, it is not protected. Now, or why is this important to know what type of work you are dealing with? It is because each type of work has its own set of rules. So even though the copyright term is 50 years, you don't start counting at the same point for all types of work. That's why you have to know what type of work it is. The authorship rules are different. The ownership rules are different. The exceptions are different. And so we can go on. So you need to know what type of work you are dealing with. Just to throw in an example here, the whole Taylor Swift debacle a few years ago. So she was not the owner of the copyright in the sound recordings of her songs at that stage, but she was the owner of the copyright in the music and the literary works. So when she and the owner of the copyright in the sound recordings didn't see eye to eye, she could go and record her songs, make new recordings of her songs, and convince her followers to rather listen to the recordings that she is the copyright owner of. So you understand that split. You have one song, but you have 3 types of work. The lyric is a literary work, the music is a musical work, and the recording is a sound recording, and each type of work has its own set of rules. Then when music gets played in public, let's say in a club or a DJ is playing music, or in a shop or on the radio, The composers of the music and the record labels who own the sound, the copyright and the sound recordings, and the performers, they all need to get royalties. So luckily, these artists, they don't have to go to the owner of the shop and say, hey, you have to pay me. That shop or that club will get a license, typically from a collecting society, and then the collecting society will collect the royalties and pay it over to the composers and the artists. So typically, luckily, there are people in the audience who know more about collective management, but as I understand it, typically like Sampro will be protecting for composers, and Sampro will be collecting for the record labels um, and the performing artists. Those are just examples. There are many collecting organizations. The sixth thing, copyright subsists automatically. So you don't have to register, and in fact, you cannot register copyright in South Africa. That's also one of the things that the countries agreed upon, is that registration should not be a requirement for copyrights anywhere in the world. Now you will tell me, oh, but there is a registrar for copyright. And in countries like the US, registration is possible, but that is not how you obtain a copyright. In South Africa, you can only register copyright for cinematograph films, and that's not a requirement. It's just a way to prove that that you have the rights. So to come back to an example, you had this idea for the song, you went out and you recorded it on your cell phone. That means you have copyright in that song because you meet the requirements. What are the requirements? Firstly, there must be a work, obviously, because that's one of those 9 types of work. Like, let's say it's a musical work. It must be original. Standard for originality is not particularly high in South Africa. It doesn't even mean it needs to be creative. Just about how much skill and effort you put into that. So it must be original, and then it must be in material form. If you recorded it on your cell phone, you meet the material form requirement. And then there are some formal requirements that you have to meet. One of the one is relates to your nationality or where you are domiciled or resident, and the other one relates to the country of origin. So if you're in South African, here in South Africa making your recording, no problem. You automatically have copyright in that song. It needn't be published, anything like that. If you write a lyric, if you write it on a piece of paper, put it in a drawer at home, that's already copyright protected. No registration required or possible. Also something about the copyright sign, the little C in a circle. If you put that somewhere on your music, a website or a CD or wherever, that doesn't give you copyright. It just tells people that you are claiming copyright so that they cannot say they didn't know. Because for some types of infringement, guilty knowledge is required, and that copyright notice helps to prove that somebody knew or should have known that there's copyright in. So the 7th one, the copyright owner is not necessarily who you think it is. So never assume. The Copyright Act gives some guidance. For example, if you commission a songwriter, you're a performer, you can perform well, but you can't write songs. So now you commission a songwriter to write a song for you. That's a literary and a musical work. I like music, like you tune, shoot music, not the recording. If you commission a songwriter to write a song, that songwriter will be the copyright owner even if you paid him. If you commission somebody to make a sound recording for you, you who commission and pay will be the copyright owner. If you commission photos, like promotional photographs of yourself to be taken, you pay for it, you, the commissioner, the payer, will be the copyright owner. So those are the default rules, some of them that are given by the Act, but they can be changed by contract, which needn't even be in writing. And if the copyright has already vested in somebody, it can be transferred to somebody else. We call it an assignment, and that needs to be in writing and signed. Copyright ownership is a real minefield. So there are also even more complicated commissioning rule changes proposed in the Copyright Amendment Bill. So what I just want to say is beware. Beware of making assumptions about who the copyright owner is, and beware of what you sign or otherwise agree to. The eighth thing about copyright is that it is a balancing act. So it is the rights holder versus users. So recently, in the last few years, we had a series of cases called the Blind SA cases. That is where Blind SA went to the courts, first the High Court, then the Court of Appeal, then to the Constitutional Court. The Constitutional Court ruled on it twice, actually, where Blind SA asked for exceptions, saying people who are not blind do not have to get permission to read a book. But if I'm blind, I have to get permission to turn a book into a braille copy for me to read, like people who can see just can do automatically. So we need a copyright exception, please. So in this case, what came out so beautifully is, on the one hand, you have the rights of, or the owners of the rights in this copyrighted works, the copyright owners, the books, for example. And on the other hand, you have all the rights of the blind people. Their right to dignity, their right to access to education, the right to access to culture, and just equality, to be in the same position as people who are not blind, or a comparable position at least. So it was this balancing act, and even though nobody really opposed it, I think generally everybody would want blind people to have access to the to works. The court really looked at this in much detail, because you still have to balance the rights of the different parties. And in the end, just last week, the Constitutional Court, the Constitutional Court said it's only going to give an exception for blind people, because the blind people came to the court to ask. And last week, the court actually expanded the exception to all people with disabilities. And that is relevant for us, because that also now includes people who are deaf and hard of hearing. That relates to music. So let's say you are a music interpreter. So that's a specialized sign language interpreter. I watched the video this week because it's so cool. I don't know if you've seen it. It's not only that they are signing the lyric, but also signing the music, the vibe, like the bass. It would be showing, you just get the feel for the music. It's a real art, right? So that they keep creating. Number 9, copyright. Copyright can subsist in infringing works. This is so interesting. And the easiest example to explain it is, let's say there's an Afrikaans song lyric and you want to translate it into Spanish. The translation right is one of the copyright owner's rights. So you need permission from the owner of the copyright in that literary work, that lyric, to make the translation to Spanish. Let's say you don't get the permission. Now you're infringing. But your Spanish translation is also protected by copyright because it's original. It's in material form. You meet one or two of the formal requirements. So you have copyright in your Spanish translation, but you're also infringing in the English one. And that is actually possible. The infringement doesn't cancel the copyright. Okay, you now just need to get a license from the owner of the copyright in the English lyric. And the last one, authors have moral rights. And in South Africa, there are 2 moral rights that are recognized. The first one is the paternity right. That is a right to claim authorship of a work. For example, in Afrikaans music, Matthys Roots, he's very well known for a song that he performs, In My Lewe. So that song is associated with him. But Matthys Roots makes no secret that it is not his song. He didn't write that. He didn't compose that. He was at a gig of a group called Die Kalkop Waarheid. And Nardus de Plooi, that's his group. Nardus de Plooi is the composer and the writer of that song. And Matthys Roots tells that to people. And I think that is just so nice. Not only is it one of the moral rights given by the Copyright Act, but it also brings a different layer to the experience of somebody in the audience. It is nice to hear where this story comes from. It's good to know that Valiant Swart wrote Songvanger, that many of Lorika Rau's songs were written by her husband. So do that. I think it is nice, and with not waiting for that composer to have to come to you and say, please acknowledge that I am the author of that song. And the second moral right is the right to object to any modification of the work that is prejudicial to the honor or reputation of the author. So if your work is changed in a way that is just so bad for your reputation or honor, then you can object to that. But also keep in mind that the Constitution does protect freedom of expression. So there is room for parody and all that. Again, it's a balancing act. Okay. Those are the 10 things about copyright. Thank you for listening. I know it's more difficult to listen than to speak.
I did copyright in my undergrad degree, and I also did copyright in my LLM. But I've never seen somebody summarizing copyright so beautifully in just 10 slides. I think that, no, I think honestly, like she said, she touched on a number of things. But I'm not going to let her go elsewhere. I would like to talk today about the copyright. And being a patent attorney, to me, territoriality means that if I don't have a patent in the US, I cannot, I don't have a right in the US, meaning that I can't even institute infringement proceedings against anybody who is creating my product in the US. However, I would like Prof to explain, that territoriality, because in respect of copyright, because my question is, if I have we've all know Jerusalem, the song, and Jerusalem, the artist in South Africa, I'm assuming that he has copyright in South Africa, but my understanding that he managed to institute infringement proceedings in other countries where people were using his song. So I just want Prof to explain, whether things like global streaming, if somebody is globally streaming, how do I enforce cross-border copyright if I'm just a South African? If she can, because I don't want people living, especially when we say territorial, we are saying that you don't have a right in the other country. But I just want, in terms of copyright, if you can clarify that, because in my limited knowledge of copyright, when you talk about territoriality, in my mind is like, oh, I can't go in that other country. But can you just explain to us, with regard to global streaming, is it possible to institute infringement proceedings over cross-border countries?
Okay, firstly, let's go back to this. So the conventions that countries entered into, the Berne Convention and the TRIPS agreement. So what I emphasized is that they set certain minimum standards, like for example, 50 years duration for copyright protection. But one of the other things that they agreed on, one of the other key things, is what they call national treatment. So if I now write a song today here in South Africa, I meet all the requirements, it is copyright protected, but under the South African Act. Now somebody performs that or copies that, infringes that in the UK, for example. Then because South Africa is a member of the TRIPS agreement, and the UK is also a member of the TRIPS agreement, they agree to this national treatment principle. What that means is the UK, where my work is infringed, will treat me as if I were one of their own citizens. They would treat me like a UK citizen. Remember the Umoya case? So it will be the court in England, and it will be looking at the law of the UK, and they will treat me like one of their citizens. And let's say, sorry, I don't know off the top of my head how long copyright is protected in the UK, but let's say it's protected for 70 years, which is longer than in South Africa. That is the rule that will apply to me, even though I'm South African, because I'm looking at the English law. And the other way around too. So if somebody from the UK that has copyright there, if I infringe in South Africa, what will apply is the South African Act, there where the infringement takes place. And the South African court will have jurisdiction. And this is now one of the problems when it comes to indigenous knowledge. If there's not an international agreement on how to deal with indigenous South African music, and South Africa takes the initiative and says, okay, we are going to protect indigenous music in South Africa, as they want to do through the Intellectual Property Laws Amendment Act. Then, if the indigenous music is infringed in South Africa, then we have our act, we have our court, we have a case. But if the if our, for example, what are you going to do about it? Japanese law does not protect um, protect your work, so you don't have a foot to stand on, and that is the problem. That we, even though we want to do all these things and protect our indigenous music. With indigenous music, I mean works that belong to an indigenous group. There's not an identifiable author. It belongs to, let's say, it's a Ndebele song that belongs to the Ndebele princess. And now we take initiative and we protect it. It's fine in South Africa. You're actually only taking royalties from your own people, from other South Africans, but you can't enforce it overseas. So that's one comment. And the other thing is just quickly about collecting societies. I'm very glad to know that there are people in the audience who know more about collecting societies. But as I understand it, let's say somebody is playing your music in a shop in Kenya. Then the idea is, or where we want to be, is that a collecting society in Kenya collects that royalties and then maybe pay to a South African collecting society that you as the artist and the composer is a member of, and then you get your payment at the end of the day. So there's a lot of work being done, also by academics, to get this cross-border collecting society agreements and things in place. So that it must be an automatic flow of royalties, that you don't have to go to court. Just, people using it, get the license, pay, and then the money must actually get to the artist and the composer.
No, thank you so much. Thanks for that explanation. Just two more questions before I allow the audience to also ask questions. So I just want us to look at infringement. And I know a lot of artists will be saying, but I gave credit. I mentioned that it is DJ Maporisa's song. So I gave credit. And others will say, but I only % of the song. So I want Prof to just explain to us how will those kind of people be regarded as not infringing the song, or what would happen in that regard?
Okay, so the test for copyright infringement is you must take a substantial part and there must be a causal connection. So substantial part can actually be a small part. In South Africa we have thank you. In South Africa we have a copyright case dealing with a computer program. That's actually also a good example, even though it's not music. So it was thousands of lines of code, but all that the programmer of the derivative work took was like 66 lines. And the court said that is a substantial part, because the reason he copied it was because it was a difficult part of that computer program. So substantial doesn't mean everything. It doesn't mean it has to be much. And it is vague. That's why we have court cases where people go to court for the court to decide, because both parties think they are right. So it must be a substantial part. I'm not a musician myself, but as I understand it, the argument is there's also just so many ways to make music that there will be some overlap. Ed Sheeran case relates to that. Okay, so and the causal connection. So if you come up individually with the same thing as somebody else, or that same little bit, you haven't copied. It just so happens that two people come up with the same thing. That is possible. And copyright recognizes that it is possible. That's a difference from patents. Patents, if it exists somewhere in the world and you come up with it independently, it doesn't matter. It already exists. It's not new. But copyright acknowledges that different people can come up with similar things. So it needs to be a substantial part, and it needs to be copied. There must have been copying. Check and copied it. About recognizing, if you give recognition to somebody else, that doesn't excuse infringement. So you need to distinguish between the exclusive rights or the economic rights of the copyright owner and the moral rights of the author. The moral rights is your right to be acknowledged as the author and that it may not be distorted. Those are the moral rights. It stays with the author. Even if the author signed away all rights in the literary work, the musical work, everything, the author keeps the moral rights. That's always with the author, and it can even be inherited by your heirs. So those are the moral rights, and if you acknowledge somebody, that is not going to excuse any infringement of economic rights, like the right to reproduce, the right to make an adaptation, the right to perform, and those are with the copyright owner. So distinguish between an author, copyright owner, it's not always the same person. The economic rights is with the copyright owner, the moral rights is with the author, even though the author is not the copyright owner.
Okay, thank you so much. Before I ask the last question, are there any questions from the floor? Can we have a mic, or do we? You can go ahead, sir.
Press. Oh, sir, thank you. Okay, thank you so much. I think my question is on number 6. The copyright subsides automatically. Actually, to ask this question, I'll just make an example of the case. I'm not so sure if the case was formally recorded, but it was a case that was making rounds in the social media in South Africa. There's a football club somewhere in the Cape Side where the supporters decided now to compose.
So a copyright is very fact specific. So a copyright is very fact specific. So you really need to unpack all the facts. Really need to unpack all the facts, and then to apply the law to that. So, but yes, I apply the law to that. So, but yes, I can see why that is a problem, and I can see why that is a dispute. That's actually exactly where the tension lies. That's also where the tension lies with the indigenous work. So you have this oral tradition, and now I go to the rural area and I listen to the music, or I make recordings, and then I go and record it, and then I get the copyright in that song. So there's definitely a tension there, and also remember the Constitution is the highest law in our country. So sometimes, even though if you look at the Act itself, it doesn't give the solution or the answer you want, then you can go and look at the Constitution and see if maybe if you put the glasses of the Constitution on and you read the Act through those lenses, if you don't see something else. I hope that somehow helps. It's very interesting. You must please tell me more about that. I want to follow that.
Okay, looks like I didn't read the house rules. Apparently, we will ask questions after all the panel, all the panels are completed. Just one last question from me. Prof touched on the new the copyright amendment bill. So I would like you to just share with the artists what are the things that they should be looking forward to, or they should be preparing for, just briefly.
Okay, briefly. So it's the two bills that go together, the Copyright Amendment Bill and then the Performers Protection Amendment Bill. So what we are looking very much forward to in the copyright world is next week these acts will be in the Constitutional Court because the president didn't sign it. He had some constitutional reservations, and that's why it is being referred to the Constitutional Court. But generally, this legislation, there are many more and wider exceptions. So traditionally, South Africa is a fair dealing country. If you want an exception, it must be for a very specific purpose, and it must be fair. While in the US tradition, they work with fair use. So it's a combination of those exceptions. So generally, more exceptions for users. But remember, not one of us is only a user. So we also can't get too excited about more exceptions, because we are also creators that want our own work to be protected. So sometimes you have the hat of a user on, and sometimes you have the hat of a creator on. And again, we need that balance. And then there's what's also in the pipeline is just new rules relating to the collecting management organizations. Many attempts to try and help with that flow from where it is played in public, your music is played in public, to where you actually get the money for the work being played.
I understand there are also people online. Online people, please just write your questions and we will take questions later. But thank you so much, Prof, for sharing your knowledge with us. Let's clap hands for Prof. Thank you.
Nga. Yes. COVID. publishing
I hope those who are listening, musicians and artists,
that means
So Andre spoke about, the streaming and all the other issues that, the artists are facing. Now we are going to talk about another one, the big one, the urgent question, artificial intelligence, because it's not making things easier. So we will be tackling, the most, like I said, urgent question in music today. And this, for me, the reason why I'm saying is urgent is because how do we protect creativity when algorithms can compose, sample, and even mimic human artistry. So we are honored here to have this critical discussion. We are honored to have Dr. Netsivambe from the Unisa Music Lennon's voice and generate amapiano beats, viral deepfake tracks like fake Drake of ownership. The very definition of original work, Prof spoke about originality, is actually being rewritten. And this is what AI is doing. So this is not about lawsuits. We've seen quite a number of lawsuits, but it's about safeguarding the future of South African music while embracing innovation. I always tell people that AI is here. So it's either, you jump in or you'll be left behind. So we need to talk about how do we still safeguard the future of our artists, but while embracing this innovation that that is currently here. So please join me in welcoming Dr. Netsivambe as well as Mr. Mbele as we explore this exciting yet brave topic, the impact of AI on music copyright. Good morning. Yes, it's still morning. So I like what Andre also said, that you must read your contract and then go to the lawyer later. So I always say that you don't need to be an an expert in IP. However, you must know about IP because it impacts your business. Even if you're a CEO or anything, you must know about intellectual property. Not become an expert. We will be the experts, but you must know about intellectual property in order for you to run that particular sustainable business. So we have also heard, and Andre spoke about the fact that streaming, a lot of artists are actually not benefiting from streaming. And I saw somewhere they were saying about 120,000 tracks are actually being loaded on Spotify daily, not monthly or anything. But Andre just told us that that is not benefiting the artists, that other people might be benefiting. So, and also I was reading on a report by Markets and Markets, which said that the AI music market is projected to hit $2.6 billion by 2026. And from fake Drake going viral to the DJs who found to be experimenting with AI voice cloning, I just want to ask you, Mr. Mbele, to start with you. How do you define the role of AI in music today? Is it a collaborator or a tool or a disruptor? Or what is it?
Thank you. Greetings Mbingelele to everyone. Um, it's everything, eh? It's not one off, but it is a disruptor. It is a co-creative tool that you can use as someone in the industry in different parts of making the music, distributing the music, mixing, mastering, doing quite a number of things. So it's still very much at a level whereby a lot of people, not only just in the continent or in South Africa, we're still trying to understand what impact it could make in the industry. But the signs are there that there is some good and probably 10 times more of the bad.
So it's not balanced. So we've also called, there is a startup called Boomi. I don't know if you've heard about them, where it allows users to generate songs in just seconds. We've also seen what TikTok is doing, using AI as well. Again, to you, Mr. Mbele, can you maybe share some examples of how South African artists or even music labels have already started using AI, either for better or worse?
So there's a number of ways that we could use AI in different stages of making music. One would be in music composition and songwriting. Like you're saying, there's generation, or you can generate music quite easily. You can do reference songs, you can separate stems, do quite a number of things early. So it could assist you in the creative process as a tool, right? But the negative of that, like you are saying, is that it also then disadvantages musicians when it comes to sync deals with other users, music users, like your advertisers. What the musician can do, the advertiser can do, sitting on their own, describe the mood that they want, look at the scene, and just press a button and see if an AI can create something for them. So there's those clashes in terms of what it can do. And like voice cloning, you said that, right? One morning, The Weeknd and Drake found out they had a song. It was online, they were not involved. It was topping up the charts on Spotify, right? So there's 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 a big question around authorship. It compromises a lot of things in that space as well, right? But it could also help if Drake was the one who was doing that, using his own voice, adding melodies, playing around with AI. He could also do that, but it opens up another avenue for everybody else as well. With mixing and mastering in production, you can, AI can assist with that, but it also assists with music discovery, because you see platforms like your Spotify and a number of other platforms that then are able to create, it almost acts as a tastemaker. According to it curates according to your likes, right, on these platforms. So there's a number of ways that AI is being used, and for the good and for the bad.
I think they said that you work with a pool of talents. So I was interested in hearing whether currently in South Africa, is there anyone who's actually embracing this and using it to generate music? Have you heard somebody saying, I'm busy using this currently and this is how is assisting us? Or we are not yet there?
I think there's some elements that we use, right, in terms of AI, in production, with auto-tune, with some of those elements, right? But I don't think we've delved into it in a way that some of our counterparts internationally are doing, right? You spoke about the number of music that gets uploaded onto streaming platforms. And quite recently, Deezer, which is a smaller streaming platform than Spotify, reported that they have to take down about 20,000 songs that get uploaded daily onto their platforms, right? So there's the use of AI outside of the country is still it's it's shooting up, right? But locally, I we don't really have instances where people are just owning up that I've used AI here or pushing it out, maybe getting some stats from Samro and some of the collecting societies might give us clues in terms of where we are going. But I find that use locally has not gone to those levels as yet. Maybe still because we're still happy about our piano, we're generating our own sounds. We're still very much creative as South Africans. Yeah.
You are correct. We are the most creative people when it comes to music. Prof. Netsivambe. So I saw. I think it was on X. There's a musician called Grimes. Apparently, her real name is Claire Boucher. I don't know her. So she posted on X and said that I'll split 50% royalties of any successful AI generated song that uses my voice. And then she also said that the same deal I would do, with any artist that I collaborate with. And she went on to say, feel free to use my voice without any penalty. I don't have any label. I don't have any legal bindings. So this post, it raised quite a lot of copyright questions. And my question to you is, in South Africa, if AI generates a track sampling Miriam Makeba's vocals, who would own it? Would it be the programmer, the user, or Miriam Makeba's estate?
Thank you so much. I like the way this artist made it obvious and clear that I'd rather share my profit with whoever that's going to alter my song or use my voice. And then at least at the end of the day, I am not going to fight with anyone. I've made it open. Use my voice, use my song. Let's just split the share, the profit. And I think this is how we should think as artists, as creators. We are already living in a digital space where things are changing so quick, very rapid. Prof, you spoke about the idea we have in our mind, and then we go outside, we record it on the phone so that we don't forget the melody or the music, and then we own it. We should also understand that there were times when this was not possible. So if you had an idea, you could not record it. You will forget it, you will lose it. So what I'm saying is we need to move with times. We are already living in a space where AI is taking over in terms of augmenting human creativity. A lot is being created and it's being generated by Gen AI. So we need to also adapt. That means ownership is always a problem. Big international bodies are struggling with this. They actually still don't have a solution. Yes, there is an agreement that AI does not own. Amongst a lot of these bodies, there is an agreement that it cannot own because you need to activate it. You need to prompt it. You still need to do something as a human being for it to do something for you. So in that way, there is still someone who owns. So there are a lot of debates in terms of ownership. And all these debates are centered around a human being cannot be overtaken by a machine or by device. A human being still has that. We have flesh. We think. We can touch. We sense. We smell. Something that AI cannot do. So issues of ownership are always are blurred, but I know people are discussing, people are trying to find ways to help creators to understand that they are actually the owners.
Thank you for that. So, when Prof said, doctors said, AI can't own, it made me to to be reminded about a patent that has been granted to an AI, because that because it's IP, and but I hear you when you say that we don't have answers. This has actually found us questioning our legal systems, whether is it are they sufficient to actually be able to deal with what AI is bringing. But I just want to also ask you about, I mean, AI is trained on a lot of songs, millions of songs. Does the output risk plagiarism? Or then how do we also define originality? And I know, these questions, there aren't answers, but I just want to poke your mind to, with especially being in an academic setting, just to hear what are people saying with this, AI, what AI is doing to what we already know, or is actually, bringing changes.
That's very interesting. Look, my panelist said here that there are good and bad things about AI. So we should just use AI ethically. That's the most important thing. You have to make sure that you acknowledge the source and the owner if you are using someone else's work. So it must be ethically used. And there are issues of ownership, we understand. There are issues of copyright, we understand. But we just need to be ethical about it and be frank that it's not going anywhere. It's here to stay. And they're even coding more and more complicated AI codes that are going to even alter, the learning capacity of AI. It's amazing. It becomes more and more. Every single day they're improving the code. They're improving the code. But at the end of the day, we need to understand that we need to be ethical about all these things. We need to look at at how we're using AI, and we need to give credit where it's due, because otherwise, then court cases start coming up, and you have to defend yourself, and so on and so forth. So I would say that it's helping, and at the same time, it's damaging, because those who are not able to use it ethically, they end up, in courts, they end up fighting with others. But if you use it ethically, it's going to improve your life. It's going to help you to do things fast. That's the good thing about AI. It helps us to do things quick, fast, things that a normal human being cannot do. Back then you will go into the studio. Even now, most people who prefer to go into the studio, they will go in there. You can spend the whole day working just in one song and still don't get it right. And then until the producer says, no, we're only going to take this take. Don't take another take. Let's take this one. But with AI, within a second, it's done. So we just need to adapt and know that if we do it ethically, we are safe. Maybe I just also wanted to say, according to the CSEC report of 2024, it also informs us that about 24% revenue it's going to be lost, or it's already lost to creators by now. And by 2028, we are going to see a significant leap of revenue created by AI, just from 3 billion euros to 64 billion euros. Work that is produced by AI. Now, creators are losing revenue right away. People are more attracted to AI music that is produced by AI. And what does it mean for our creators? They continue to lose revenue. So there needs to be laws that protect creators so that they are able to at least make money out of this and dive into it. Thank you.
Thank you for that. I wanna. There's a question I want to ask you, but I want to take this question to Mr. Mbele. You're talking about, it looks like the people who own, the AI and the system. Those are the ones who are going to be making money. But for their AI to work, they need my music. So what are some of the interesting ways? And I like what you spoke about being ethical. And I want to ask you what does that mean? But Mr. Mbele, what are some of the interesting ways in which these people, as they try to be ethical, can make sure that our artists do not end up actually, dying as paupers, like we've already been seeing, while they're using their music to train their AI?
Thank you. There's a there's a big role to be played by policymakers, right? I don't think we should leave it to people that look at this and talk numbers, and it becomes just economics and money, capitalism. So we cannot leave it to them to be ethical. They have to be pushed in a manner that they act, you know, in that way. So there's a there's research that just came out in the US, and just after it came out, the lady in charge was actually fired by President Donald Trump. But what they found was that this area of fair use, right, which is what is being used, it favors the users more in the States, which is what we are debating with copyright amendment bill in the country, is that there's always a gray area, right? There is some advantages when we're using other people's work, right, to advance all of us technologically. But there's also massive areas where people use these works to train these AI agents and all of that only for them to benefit, right? So that it's murky waters. So there needs to be a way that we bring in policymakers. There needs to be a way that you bring in your CMOs, you bring in all the distribution platforms and everybody else involved to come up with ways that we make sure that all the tech companies, they act accordingly. That's what I think is important. Um, Going to your question, right? There's AI could be a beautiful tool, right? But looking closely, I think it is important for for authorship, for definitions, for certain things to be really classified, right? Because when when you look forward, there's this podcast that I usually go to. It's called Diary of a CEO, and one of the guests there once said that whenever there's new technology coming in, we always underestimate its impact, right? You look at what people were thinking cars would be, right? You look at what people were thinking airlines and everything else would be, right? And I think we should treat AI in such a way that we do not have a clue how this is going to turn out. And like the prof is saying, it's in the manner that it is learning and it is adapting and things are changing, right? They're changing so fast that our copyright law is from 1978. We're taking close to what, a decade to decide how do we bring it up to these days. And the more time that we are not getting it done, there's always something else that's popping up. So there's a massive need that we bring in policymakers, we make sure that we have something that is consistently monitoring, and we make sure that people act ethically.
Thank you for that. And I hear, when we're saying that we need to change policy, but I also hear when you say that we need to act ethically, because it's taking us more than a decade to change the Copyright Act. Yet the musicians, the revenue is actually trickling down. So for me, this ethics, and I've seen it with a lot of companies, or not a lot, a couple of companies already in the US starting to come up with a fund where, and it becomes difficult, but they're trying to see how to compensate. If we have used your work, we need to be able to compensate you. It's a tricky one, but they've started doing it. Another thing is to look at things like royalty tax. The thing is we need to become creative. While the law is changing, we also need to act ethically and understand that this person created this music and now I'm using it and I'm benefiting because I have this AI machine, but his revenue is actually depleting. So I think I hear the call for policy, but maybe while we are waiting for policy to change, let us start acting ethically and understanding that it's somebody's bread and butter that is actually going down the drain. So, Prof, Dr. Netsivambe, we've seen the EU taking a lead with regard to AI. They came up with an AI Act, and they are saying that there must be disclosure of the AI content generally. And then the US came and said, they denied protection for anything that has been purely created by AI. We are now looking at the Copyright Amendment Act, and I'm not certain, does it even address this AI? It's addressing, other issues. So the question is, are our South African laws even ready? Is there anyone that we can try to model or to try to look up to? How are we ready? And are we actually moving at the pace that that AI is actually moving at in order to correct or improve our laws?
Thank you. I don't think we're ready in a sense because most of these laws are created to protect works that are created by human beings, and anything that has to do with interaction between human beings. So these laws are created to protect human beings, but not to protect works that are created by machines or by AI. So that means we need to move with that kind of thinking that we need to then incorporate the use of AI into these laws so that when people want to start fighting about who owns the work, who is the original owner, and when we go to the law and to the act and find out that the law or the act cannot protect you because it doesn't mention it, it doesn't say anything about AI. So it's a big challenge, but I think even when we say we go back to the issues of ethics, this is very subjective. I'll give an example. I mean, all four of us, we will have different treatment to a 10 rand that someone dropped it on the floor, and we all saw that it's that person who owns it. One of us can just hide it. Another can say, hey, you dropped 10 rand. And it's just, we just need to understand that, we need to be fair to each other. Ubuntu, we need to live as human beings. And if you know that something is not yours, acknowledge it's not yours and go and find the right protective laws and clauses or acts that can also protect you as the, maybe reuser or user of someone else's work. So yeah, we are not ready. I think we just need to do what we can and conscientize people about the use of AI and making sure that they should not be on the wrong side of the law, but try to think ethically as a human being. Thanks.
No, thanks for that. So there's a study that was conducted by a music distribution company, DITTC, who said that nearly 60% of artists are actually saying that they use AI, probably is international in their music projects. However, about 28% say that they would not or they'll never use AI for their music projects. So, and Prof said, Doctor said that when I was talking about that other artist, he said that it's good because this artist saying, I'm willing to collaborate. But Mr. Mbele, and probably to both of you guys, are we ready? Because yes, if I'm a DJ Black Coffee, I can afford to license my voice to an AI company and get money. But what about grassroots artists? Are they not getting, squeezed out? Actually, the gap is is it not widening? While we are embracing AI, and I always say, even with other IP legislation, we probably need to look at what the country needs at a particular moment, rather than just taking everything. What about those grassroots artists?
Um, it's an interesting case of the artist actually giving everyone permission to go ahead and use her voice, use her cadence, whatever, to produce the music, because we also don't. I don't think we have the right laws in terms of CMOs to actually pay for AI, how much of the of 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 the song will an AI own, or who owns that part that was not necessarily written by a human being, and how does that work? So within the way that things are set up in our country, it will be very difficult to adjudicate on that song. It will almost be like you're looking at works that falls in the public domain, like the song Aspelelanga, which Andre, I call him Mr. Lerumo, will raise quite a number of questions around that. Do we then end up saying that you are only looking at 16.6% of the song? Is that what you're going to be working on, and the rest falls onto the public domain, right? There's just a number of questions that are raised by that, right? And when I'm trying to get to your question, what's the question? When mm, so when you go back to music, right? At the moment, the gap is widening in terms of the production element, getting the song done much quicker because you have your reference work, you have all of that, right? But in terms of the creativity that is there, or at a level whereby indigenous music and all of those sounds, it's still very much us that are needed to make sure that is there, because you need to create that number of data sets, that number of recorded materials, so that AI can learn this thing, and then it can then reproduce it to the same level that we can after a while, right? So there's an advantage of where we are and what we are producing or taking out in terms of our recorded material. But after a while, um, I believe that you need the human element, right? Because you can produce music. There's a difference between amapiano in South Africa and amapiano in Nigeria. There's a difference between the song that's produced in the US trying to mimic what we do with us, right? Because there's a lot of other elements that make up a song that are not really technical. They come from experience, they come from a touch, they come from an ear, a human ear, Not that you went for frequencies or you cleaned up certain things in a certain way, right? So there will always be an element of human creativity that is needed, right? And that's why when you look at AI, you could use it as a co-creative tool, right? As a tool to make better what you're working on, right? Especially if you have that ear, especially if you have that touch, then it will work amazing for you. But the problem is, um, if you let it go to AI only, it loses something. Amapiano becomes too clean, right? It doesn't sound like it's something from a Soweto, right? So there's all those elements that are there. But yes, it is important that we look at what we are doing. It is important. I'll go back to police, I mean, because I believe that we should really look at our laws and police from the onset, not later, right? There's an example again that Mr. Lerumo said that I'm not going to repeat because I respect my elders. Right? So we need to make sure that we don't do this after the fact, right? So we need to kick off from policy, make sure that we force people to be ethical, make sure that we understand that the fair use clause, maybe put that aside so that we still continue with fair deal and make sure that we protect the creators, right? It's still very much necessary in South Africa. And also those up and coming guys, those guys that are in the rural areas that are playing around with music, playing around with a lot of other stuff, we still have an issue of just understanding IP, right? Just understanding copyright. And with this extra layer, now you're saying, who wrote this? How did they write this? How much did they own? Does this belong to you? Right? So there's a lot of groundwork that we need to do, but also from a policy perspective, we need to protect the guys that are coming into the industry and the creators themselves.
I think just to add, I think going back to what Andre said, um, he said knowledge is key. Advise people to learn and to know. Because when they know, they can make informed decisions. They will then decide whether this thing will work for them or it will not. In fact, it can change them for the better. You may find out that they realize they were, wasting so much time and energy. AI can actually help them to create so many albums. So people just need to be exposed to this information because it's out there. Then they'll make the decision. And they'll also find ways of protecting their own creative um, work from others who can copy from them. Because when you know, you continue to learn more and to learn more so that you know how to protect your own work.
Thank you for that. So as we wrap up, and I want us to zoom out to the future. So there was a report by Goldman Sachs which predicts that 30% of global hits could involve AI by 2027. So I want us to bring it home. And it actually made me to raise two questions. I'm going to ask the first one to you, Mr. Mbele, and the second one to Doctor. So for the industry, should your Samro and Capasso pioneer, and then you've touched on this, but I want to go back to that policy. I want you to give us that policy, that one policy that you want us to push today. So, but should Samro or Capasso pioneer an AI royalty initiatives to track and distribute earnings from AI generated works? And if you could push one policy today to protect South African artists in this new, exciting yet challenging era, what would it be?
We would scrap the idea of fair use, stick to fair dealing, right? We would look at making sure that we update the copyright law to define authorship, right? Also talk about AI contributions, and we can really look at what the UK is doing in terms of making sure that you need to actually notify and say that I've used AI here, right, so that we are aware. And we need to move to a space whereby we're able to protect cultural and indigenous works, right? That is key because as we digitize, then we know that what we've digitized, we own. It belongs to our communities, it belongs to us, right? Yes, we need to encourage AI innovation, right? Because it makes things easier, because the creative output will be amazing, right? Um, but key and above all is make sure that we deal fairly and ethically. That would be the primary policy that we'll push for. Vote for me in the next.
Yeah, and I think just to add, also to you know get exposed to international instruments such as UNESCO that have various conventions that protect our cultural heritage and so on and so forth. So we are able to even tap into those instruments and push government to come up with policies that can protect the works of creators. But most importantly, to make sure that um, AI is here and it's going to be here even in the next coming years. So we just need to understand how to navigate around it so that it doesn't, outdo us or take all the revenue that should go to the artist. But tech companies are the ones that are going to make so much money. Even CSEC report says by 2028, tech companies are going to take so much in terms of revenue, close to 28%. And that is now going to take that are developing percent. So by 2028, tech companies are going to take so much in terms of revenue, close to that 28%. And that is now going to tech companies that are developing AI tools and so on and so forth. So we just need to find ways of protecting what we're doing, work with these tech companies so that we split the share, not that everything goes to them, because they will still own the copyright of the coding of developing the AI tool itself. But what it's doing, it's also taking from other people's creation. Thanks.
And I just wanted to add that, with tech companies have always used the creative sector and they've always exploited the creative sector. And we should learn from when file sharing was coming in, right? And that we really can't fight tech. We really cannot fight change. But it's really important that we make sure that they know that we are the ones that own the content. They might own the platform, but we own the content. And therefore we should be treated accordingly, right? And retain the IP.
I like it there because I always say without the artists, we wouldn't be having this conversation. They wouldn't be having that AI system. So, and I think that is important. Without the content, they can't train their AI tools. So, you're right in that they need to treat artists accordingly. Doctor, just a last one, probably second last one. Probably maybe there's an piano producer here who's sitting and intends to start using AI to craft his beats tonight. What is it that you can tell him in order for the person to harness, AI's power without ending up in some copyright disputes? Maybe they're busy because you kept on saying we must embrace AI, we must embrace innovation. So that piano producer is about to go and use this AI. what is that golden rule that you can probably just share with that particular producer so that it doesn't find themselves in, some copyright dispute?
Thank you. I mean, we do have companies that share beats or loops for free, and they are not copyrighted, those loops. Anyone can download them and use them. So you can just play around with those as long as you know that you're not taking loops that are protected. And you have the system in front of you. Generate music, but always make sure that whatever you're using, it's not copyrighted. And it's from the public domain and can be downloaded by anyone. Yes, we're going to get, you know, the same thing all over again and again, but treated differently based on who downloaded it and how they treated it, how they made music out of it. But it is the world we're living in. People are using that space. You don't have to reinvent the wheel. The loops are there. There are people who just generate loops. So you can find those loops, you can find those samples, use them in a way that they benefit you, create music out of it, as long as it's free loops.
Okay, no, thank you so much, gentlemen. I think what I'm taking, and I'm not certain about you guys, is that AI is here to stay. It's not going anywhere, and we have to embrace it. But like Mr. Mbele kept on saying, policy is key. It is what is actually going to take us or to move us forward. But also importantly, we can't leave ethics. The ethical use of AI, it's also something that is going to keep us going. Ethical use means that being transparent, meaning that disclosing where you have used the content or where you have used somebody else's content. However, also compensating the people whose content you have also used. So with that, I just want to say thank you so much. I don't know if you have the last words that you want to say before we close. But thank you so much to both of you for sharing, your insight with us. And I'll hand over to the program director. Maybe I'll give it. So before I just wrote to say that DTII, DTTI, as well as Chair Mashavela Tennis, I think next time it is important that we invite policymaker as well as the tech company, a representative of a tech company, so that we can have this conversation with all the relevant stakeholders. Thank you.
Thank you so much for the eye-opening discussion. It was indeed very interesting. Indeed, AI is shaking things up in every aspect, be it in the creative world or academia. Um, I think by now we should be moving over to Q&A session, and I would like to welcome all the speakers back to the stage so that we can proceed to the Q&A session for the online participants as well as the audience in here. Question comes from Advocate Nzaluba. How do we ensure that communities are aware of the specific lifelong knowledge to protect talent and legal astutedness of young Africans? And the second one, can you please explain how is it that record companies and musicians own copyrights of church songs or hymns. A good example of this would be Jerusalem, a case between Open Make Records and Nomncebo. The song has been sung in churches for decades, and now they are both fighting for its copyright. The third question is, how is copyright infringement that takes place in township taverns without SAMRO licenses handled? Is there a copyright watchdog in place to oversee such infringements?
But I want to also add, because I wanted to ask earlier on, Prof. If I heard you clearly, you said uh, by default, recording copyright ownership would go to the recording studio if I have not paid as the musician. But if I have paid, then copyright comes back to me. Is that correct, Prof? And if that's the case, then I think you are able to help us understand that difference between who really owns in terms of recording or recorded sound in terms of the studio and the musician.
Okay, the starting point again is we have those 9 types of work that are protected by copyright. We get that list in the Act. But then for each of those types of work, you have an authorship definition in the Act. And it's not always the creator who is the author. So for the sound recording, I think it says it's like the person who made the arrangements or something will then be the author. So you go and look at the for that, you are the copyright owner. So the person responsible for the composition of the photo will be the author, but you who paid and commissioned, you the copyright owner. If you commission a sound recording and pay for it, then the commissioner is the copyright owner. So there are all these default rules there. The commissioning exception does not apply to the lyrics and to the song. So even if you commissioned the songwriter and paid for it, the songwriter remains the copyright owner. But these things can be changed by agreement. And then there's also assignment. So does that answer the question? Okay. Question 1, can I say something about question 1? So what Advocate Nsaluba was asking about is how do you make people aware of all these things? And while the last panel was speaking, something I thought of is, we always think we should change the law, but the law is always catching up, not ideal always. So there's also space for something like a code of best practice, for example, that in industry, law tells you what you may not do a lot of the time. But maybe in industry you can say, this is a code of, if you are somebody who wants to do the right thing, you want to use AI in an ethical way that is also complying with copyright law, here is a code of good practice for you, showing you best practices. And something that I saw of a best practice, it's not in music, but the principle is the same. There is an academic called Inke van Heerden who published a book of poems, a collection of poems, using AI. So what she did, she's the author of the famous Afrikaans the daughter of the famous Afrikaans author Etienne van Heerden. So Imke van Heerden did some research with a colleague of hers. So she is working at the university. She's an associate professor. So she collaborated with another associate professor who is a computer programming expert. And that software developer developed a small language model where ChatGTP is a big language model. He created a small language model. And all they trained that language model on was one book. And that book was authored by Etienne van Heerden. So Imke van Heerden went and got permission from the copyright owner, her dad, to use that book. So they put the book into the AI, and what the AI was designed to do is to come up with thousands of single lines by scrambling the text of the book. And then Imke went and she took those lines and used them to build poems. And everything I told you now is not because I know her. It is because at the beginning of that collection of poems, it is called Silver Wit en die Soontoe. Loosely translated, it's something like silver white in the over there. In the beginning of the book, and also in the end, if you read that, all of this is explained. So the point is, she's 100% transparent and ethical about this. So there's no plagiarism. She's not pretending that something is her work that is not. She explains exactly how they went about to create that book of poetry. So that is ethics, so there's no plagiarism. And from a copyright point of view, she had the permission of the copyright owner and that work was acknowledged. And isn't that such a great practice? And if you can start getting examples like that and tell people this is like an example of a good way to do it. If you want to do the right thing, here are some pointers. Rather than necessarily going after everybody you think that didn't do it right. So that's also one way of thinking about it.
Thank you, Prof. Just to add on what you just said, I've been using AI for some time, maybe 3 years now, but not necessarily in music production, but in other aspects, graphic design, etc. We run a music business conference, and where it stood out the most was last year, right? Our graphic designer, Nosipo, was pregnant, was on leave, and I've worked with Nosipo for over 10 years, right? And she's the one responsible for the brand that is the Music Imbizo, right? And whenever you go out and you're looking for someone to carry on with, with the brand and use the same, style and stuff, we couldn't find anyone, right? And then we tested that out with AI. You load up some of Nosipo's graphic designs, you play around with what she's been doing, right? And then we came up with concepts for last year's theme, right? And it came out beautifully. The one thing was just that everything it was designing was female, because Nosip was designing, from her perspective, and all the stuff that she was doing was really female. But the people, whatever that was there, it came out nicely. So for the whole of last year, what we were pushing out was just AI generated stuff with a touch of Nosip. right? Which worked out nicely for us. So I am for AI, right? And how we can use it. But to answer to contribute to the question that was posed earlier, I think it's important that we teach our communities about intellectual property and copyright, right? But in a way that it makes sense that there's value attached to music, right? That a lot of us in the country really do not, we don't look at it as a business. We don't look at it as ownership. We don't look at it in terms of the technical aspect of things, right? So there needs to be a way that we teach our communities about intellectual property so that they see that as another way, like they look at land, they look at something that they can pass on, that can generate an income, that can live within, within the family, pass it on to their children, etc. So there needs to be a way that we start looking at music as something that is that like that, and we teach our communities how they need to interact with intellectual property. I think that becomes extremely important, and them understanding the value of music. I've written some stuff down here. My phone keeps. Okay, that is one. And also, there's a need that we differentiate between live music and recorded music, right? Because we learned this as well. And South Africa is, it's like Zoma Zolo when it comes to democracy and all these things. And this 30 years, how we are contributing to the world, we're thinking it's unique, whether it's amapiano or whether it's all these sounds, it's tatamia, right? But for every Lady Smith Black Mambazo, there's like hundreds of other tatamia groups locally, right, that perform live, that don't have any recordings. So we always need to differentiate between live and the recorded industry. And also we need a way to protect the live, because a lot of people are creating competitions, performing, going out in spaces, as a collective, making music, right? How is that protected within our laws? How is that protected within our policies? What is the standard, the general standard that we can push out and say that this is a way that we can do things, right? I think that is also important. Yeah, I think that's my contribution. Thank you.
Firstly, I must apologize if I offended any elders. It was unintentional. And spare, you know I wasn't trying to offend any elders. So don't rewind that invitation to your conference. No? But it goes to what you were saying. And Advocate Nsaluba's question, how do we get people to know? And you get people to know things by speaking to them in words that they understand. The example I used is sitting next to an artist at a braai. And sometimes you need to figure out how you communicate the most complex things simply. I'm still to see the revised and edited people's version of the Copyright Act or the Copyright Amendment Bill to make those debates accessible, because often it's not accessible. So sometimes you focus on what you can do. What we do is that every piece of research we've produced has a people's version. All of that research is online. And in that way, each one of these pieces of research has got quotable quotes, models, has got examples, and have policy recommendations for and written in ways that these pieces of research can be understood and can be referenced. And I think that's the way to do it. And then also to admit, not everyone will understand everything, and not everyone will understand everything at the same level. Hence, we sometimes need lawyers. When it comes to record companies, yeah, Evans, I think the commissioned works is what you were really talking about. And I think in summary, contracts can change things and ownership, but commissioned works are very clear. You commissions and pays owns. Yeah. The the SAMRO licenses of taverns. Yes, SAMRO is licensing taverns and looking at taxis, but it's not that easy to do because it's the Wild West out there in those smaller spaces. And in a business sense, it's called the rats and mice. They start and they close, and it's very difficult to monitor and regulate. But there are tariff structures that SAMRO has put in place and other collection societies have put in place. And there are agreements and relationships that they're developing with the smaller business owners like taverns. Then on Jerusalem, and someone spoke about the church owning it, and I think that was the discussion earlier. It's probably not the church. It's probably traditional repertoire. It's probably owned by a particular community. But to track and trace and monetize, we ain't got there yet, and it's going to be a long time before that happens. Coming back to I think in South Africa, when we talk I go, I. You know, yes, it becomes the overriding thing in a lot of these debates. But I agree with you, Spare. The, for policymakers and lawyers to chase the AI is like a dog chasing a car. They're never going to catch the car, and when they get it, what are they going to do with it? But I do think that it's worthwhile chasing the car. It's worthwhile developing the policy approaches. It's worthwhile taking the legal judgments into account. I think there are 40 cases in the US at the moment in terms of AI. But then parallel to that is developing the models. And I think that's what you were talking about. One needs to develop the models of monetization outside of the legal and policy frameworks, because that's going to catch up in terms of revenue. And the Nigerians are really smart at that. A lot of money comes from streaming. So what do? They've got streaming farms, you know? So find out where the revenue is and build the collectives to do so. And sorry, but collection societies, they are going to be extinct. They're like the fastest dodo on the island. So it's important to understand that they need to also work together and collaborate and simplify what they do.
Thank you. Thank you so much for valuable insights and input today. I really appreciate the time that you've taken. Come and spend as a business day with you, with us. Uh, we have more questions. Ooh, okay. Over to you, Mr. Sia.
Thank you, Madam. I've listened to all the speakers, and everybody seems to talk about ethics, which is correct. But the thing about ethics is that it depends on the individual, right? However, my question is, on a global scale, at a multilateral level, what is happening? Are there any policies being put in place? And the reason why I'm asking that is that we cannot find ourselves as the African continent being the one who are exploited because, as you know, our policies are always slow, our governments don't react on time, and we don't have all these gadgets and instruments to come up with these policies that are talking to the technologies as they develop. WIPO, for example, is WIPO starting to have these discussions at the UN level to say, what are we doing with AI and music? And if so, how fast are those? Secondly, should we not be saying, instead of saying us as musicians and them as AI developers, should we not start saying, let's collaborate, let's start to talk about together as one, because in the past, there was Steinway and there was Yamaha making pianos and so forth. There were composers. And at the beginning, they were all clashing, but eventually they started to talk together, Maybe perhaps it's about time that we started saying, we as musicians, together with our AI developers, are coming up with these instruments, these musics, and so forth, so that it's not us and them, because the legal aspect of it is going to be long, you see, and especially us as Africans who are creative but don't have these gadgets are going to end up being on a losing end when it comes to music and creative arts and all forms of arts, actually, with regard to the laws, if they are, if not dependent on our own laws in the different countries, whereas if it's at multilateral level, maybe perhaps there might be faster ways to protect our musicians. So my question are two. What is happening at WIPO? And secondly, should we not be saying it's us and as a collective, that is musicians and AI developers, rather than say us versus them? Thank you.
two overlap. And I think most or all of the ethical concerns we were talking about, there is some law to back it up. So plagiarism is an ethical concept. So typically it will be regulated by policy or by, just where we come from as a person, which, as you said, might differ. But policies do standardize them. So let's say you are using somebody else's work to create a derivative work and you're not acknowledging whose work you are using. Then from an ethical perspective, that is plagiarism. But from a copyright perspective, it's also infringement of the author's moral rights, his paternity right, and that is a copyright. That is in the Act, and it's one of the basic moral rights that the international law says that all member countries must adhere to. So there is law backing ethics. And then definitely if you use somebody else's work, just acknowledging that person will not undo any infringement. And actually the 1978 Act is not as useless as we might think. It, together with the court cases that interpret the Act, it is very clear. If you take a substantial part without the permission of that copyright owner, you are infringing, unless there's an exception that covers. And that same principle you can apply to AI. But where the challenge now comes in, also listening to the last panel, is like, how do you track what AI was used to create a derivative work? If you can trace that, track and trace that, and let the royalty go to whoever created that first work, I think then we can get far. For a start, we might want, when you register your song, to be upfront about what you used. That can be a great start, but if somebody is not that honest, it will be great if you can use technology to trace. And why not use AI to police AI? That's one of the possibilities, that AI can actually tell you, this song that was created by AI drew on these songs that were created by these people. The people say you have to pay royalties to them. And if we can get there, that will be, that can work. But that's more a technical issue. That's not a legal thing. That is like the law. The law already has the rule, but how do you implement that in practice?
Yeah, we got to kill the CMOs. Oh, I hope they're not listening. The AI to chase AI sounds interesting. And I think what Spear was really saying is that most of it's a tool. And we need to figure out how these tools work and how they can work to our benefit as artists and as a sector and as an industry. And it's very difficult to understand because it's a very rapidly growing tool. And it operates beyond law and beyond borders. So it's very difficult to figure out. On the question of ethics and morality and law, I think that's like a whole year-long kind of exercise. For me, the challenges, and it's like whose ethics, whose morals, and whose law, because the law is different, and the law is different in different places. And sometimes the law is clear in a particular country, but that doesn't mean that it's fair. The fairness around having registered the Woodyear plant at the CSIR and selling it to the US, or registering rooibos in the US, and that's legal, but it's not necessarily fair, is a question of ethics and morals, and that's quite a rabbit hole to go down. For me, the institutions and the global institutions that are supposed to be the custodians of that ethics and morality, they don't necessarily work in the interests of an African morality. neither in terms of our institutions and our ownership. So WIPO has a lot of these discussions, but I don't know where they go. The CMOs have these discussions at CSAC, the global body, but I don't know where they go. And some people that control these discussions allow some of the immorality to take place, where works and geographical names and geographical indicators and stuff is used and abused, and stuff is lost. So how do we change that? And I don't think that's changed by law. It's changed by effective institutions. So bringing it, I'm an administrator, not a lawyer. So bringing it down to the effective institutions we need on this continent is a functional African Union. Another effective institution we need on this continent is a functional African collection society in both Francophone and Anglophone Africa. And if we just build those three things, we'll have the ability to lobby internationally.
Thank you very much to the insightful presentation. Yeah, so I will introduce myself with my alias name. I used to be an artist too. So, but in the one Uzigi, yeah, sure. So my question is like stemming from how the copyright protect us. But I was an artist outside the country versus the artist inside the country. Yeah, we had to go and fight the taboos in China. During the design, I was panda, 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 dripa. So the issue is how I also in those situations then continue further, studied the arts and culture within the university, then pursued further the talent within the cultural groups within the institutions of higher learning. I would go, we toured Shanghai, goodbye, hello. So how artists are protected, especially outside institutions, inside institutions, are they catered independently or without the stable? Vis-a-vis coming back to Ekas Mzansi, we wanted to reshuffle the genre, introduce the white guy to come and sing the Kwaito. But Mandoza and Kalagata, Serious daughter, he passed away. So how long does the royalty of the past the late artist continue to be protected before being used by another artist who's going to be passed away, like Costa Teach Who passed away. The song was still in Kalagat. And the other issue was the talent versus AI and the management. Does we also protect AI or just some other artists are still seeking for handouts? Thank you very much.
Okay, so for how long you're able to get royalties? It is for how long the copyright subsists in your work. So you have to determine what type of work is in question. The sound recording, it is, I think, 50 years after after recording was made, if I remember correctly. But then for like a lyric and music, that is longer. So that it's with the lifetime of the author and then another 50 years. So that is only then does the copyright expire. So you'll after the author's heirs can keep on receiving the royalties until the copyright expires. Does that answer that question? So after death, it can be a source of income for your family.
Samro, Strike Vilakazi's song Meadowlands, his wife made money from that song for many, many years after his passage, and it put food on the table for the family. And that's why it's important to register it. And then sometimes during the lifetime post the death of the artist, the way for it to accrue additional value is to do an arrangement, is to do a mix of that particular song, and in that way to put it into the public realm. So that goes to issues of estates and succession and ownership and all of that. Coming to your other question, which is about traveling in certain countries and being protected. Sorry, brah, certain countries, they don't do protection. So when you're there, you're not going to be protected. They don't respect copyright in certain countries, many African countries, and a lot of those in the East. There aren't reciprocal agreements between the collection societies. So the works that are performed there and broadcast in places where there is no protection won't be protected.
But inside the university institution, this university must also reach out to say, we are protecting these artists, it's our product. We are grooming talent. We are not just putting them on the stage. Yeah.
Granted, but universities also exist within territories and national treatment in terms of copyright. That's how it works. Huh?
Not all countries of the world are members of these international treaties.
Nottingham University in China. There's a Nottingham University, if you are aware. I think maybe, yeah, English University.
Okay. This will probably link when we were talking earlier about the collaboration between the music industry and the tech industry. The question that popped up was if it's done early, it happens, it can be fruitful for both. And by early, I'm saying in spaces like the universities, right? Because I think there's a role to be played by universities at that level before it becomes just commercial, before people are just chasing profits, right? Because what happens after, when people invest money, research, etc., people are then no longer just doing it for the good. It becomes within a company, within a corporate structure, and we're just trying to make a profit. And from the music perspective, if you are not of the same mindset that you understand your stuff, you understand IP, you understand all these things, and you understand that I'm in there to make money, then it becomes a whole different ball game. So if we were to ask of universities of such structures, it would be how does research early at university level, how do these different departments collaborate, right? The sciences and the music, right? Humanities, etc. Then I think that will be a much easier question to be answered in terms of how do we make sure those collaborations happen there and make sure that people are protected as they go out with whatever that they have. But like Mr. Lerum was saying, in some spaces you won't get that protection, right? Thank you.
Indeed, a lot can be achieved through agreements.
Yeah, and leveraging the intake of these other faculties, they're not taking people. Arts and culture, who's studying arts now, who's believing is going to make money tomorrow. Thank you very much.
Okay, greetings everyone. My name is Dr. Mabongo Jessica Nyamungu, and I am a medical doctor as well as a final year law student here at Unisa. During the conversation, the moderator mentioned grassroots artists. So my question is, are there any pro bono services or affordable services for registration for grassroots artists or disadvantaged, those that come from disadvantaged backgrounds, or even students who can't afford anything? Thank you so much.
Okay, I just wanted to comment on AI. I create music using AI, and I've been an AI advocate for about maybe 10 years now, to an extent that I work with a certain university, and I empower producers and artists and songwriters to make sure that in their processes, they produce music that helps them to gain, to get a market. There are songs that are on the market right now that were written by AI and we don't know. There's a song a Nigerian song called, I think My Sweet Babe or something. It's current. It's a viral hit with about 3 million video creations. That's AI. And they won't say it, but it's AI. AI is used in different forms and ways. You can do a song, the whole process is done in the studio, but at the end, when you're mastering, you use AI. Still, it's AI. The same way Fruity Loops is used, where people used to play guitar live. Now you can play guitar using Fruity Loops. You can play anything using Fruity Loops. So AI does the same. So what we need to do is to embrace the technology instead of fighting it. We used to, at some point, we were fighting Fakaza. I think most of you know it. So we told Samro, so we need to find a way to fight Fakaza. Then Samro said, we don't have the resources. Then me and my friends decided to study Fakaza. Like, how are they doing it? Why do they keep on having music online if they're not making money from it? And at that point, they had about 10 million monthly visits. And Ukos was at what, 6 million. So it meant Fakaza was bigger than all the radio stations in South Africa. So we studied their model and their system. And then we said, instead of fighting them, so we started our own. It was called Dome Hub. So from Dome Hub, that's why you have Piano Hub now. Piano Hub becomes a Piano Hub. It comes from what we were working on, what was called Dome Hub. It was for Dome. Before my piano became my piano. Then we decided to reach out to the owners of Fakaza. So what we started doing now, instead of fighting them, we started leaking music to them, of which we were in control of it. So before the music goes on Spotify or wherever, we'll give them, and then young people who couldn't afford to do on Spotify, they just needed data, and then they download the music. So by the time it's on Spotify, it's already a popular song. So sometimes we need to find ways that work for Africa. Instead of just saying, oh, it's going to take away from us, sometimes it actually empowers us if we know how to use these tools in a better and good way. Obviously, I won't say names, but yeah, I'll talk to some of the people. I know them. They know me from, I know them from how do I put it? I play a background role, but yeah, I know most of the guys that are in front there. So yeah, we'll get to talk and get to share. I've also shared some of my ideas with policy makers in terms of, at some point I was even talking to Google. Google is in Google, Silicon Valley, and also some policy makers to say, how do we make sure that as Africans, we don't just react to technology, we become role players. We play a part in such a way that we benefit from it. We see the change and it must have impact. Thank you.
Thank you. And I think that will be our last commentary and last question to be addressed by our speakers over here.
Thank you. The last one, I think it's very interesting that you're mentioning how many artists are already harnessing AI and using AI to create music, which is indeed what they need to be exposed to. So we need to know how to use the tools and how they can advance creativity, because it is the times we're living in. We're exposed to a lot, but we need to know how to use it right and ethically. There's also this saying that, AI will not necessarily take away jobs, but those who know how to use AI will take away jobs for those who don't know how to use AI. So it is more about knowing how to use it and using it right. Then you are able to generate more revenue stream for yourself. And as long as you understand the ethical implications and making sure that you're using tools that are at your disposal to actually generate more revenue. So the first question regarding grassroots and support for grassroots artists, there are non-profit organizations and even artists themselves. They try to assist those who don't have access to where they can get support and try to groom them, expose them to other tools that they can use to at least make sure that they can sustain themselves and their music can continue to go forward. It's like when you have an artist who doesn't have the opportunity to go to a recording label and record there because they cannot access or they don't have, but there are artists who have home studios where they can, record their works, support them, and make them their work more popular. And it's just that it may not be happening at the scale that we hoping for. People in the rural spaces, they are always marginalized because maybe of the distance and where they are, and they don't always get the access that those who are in the city spaces get. Thanks.
Thank you so much. I would like to welcome Mr. Noma back on stage so that we can proceed to our next item on the program. Thank you.
I think it's very important to actually appreciate, our panel members, including our program director, earlier on, the moderator for the panel sessions. Colleagues, let's give our panel members a round of applause. They've done justice. Right? They've done a really, really great job. And we've learned a lot. I don't know whether anybody saw the comments on Teams. We couldn't read all of them, unfortunately, but there were quite a lot of positive comments that were coming through on Teams. But thank you so much. So I think this is just a token of our appreciation, for really, giving us your pearls of wisdom, which we really appreciate. I think let's do it here. Just now. Okay, I'm told that we should be here. you very much. Again, to members of the panel, thank you very much. I think we can release them, right? Yeah, please feel free to take on the seats on the other side. Now we move to the next item on our agenda. So this one is quite interesting because, I remember earlier on we spoke about, the importance of recognizing, innovators. And so, this one we had to add, we had to use this opportunity to actually recognize. Perhaps maybe recognize is a very important word, but we are handing over certificates. And these certificates have been issued by the National Intellectual Property Management Office to all the inventors whose patents were granted in 2024. So, as you may be aware, this is not the only platform. This is the way that we actually recognize the IP creators. There's also within the Department of Higher Education and Training, there's the innovation outputs on the other side. And of course, the innovation outputs, the focus is on those patents that are granted internationally in examining jurisdiction. So there was nothing to actually recognize, IP creators whose patents are granted in South Africa. So the National Intellectual Property Management Organization created, the issue certificates each year, and they send us the certificates. So we thought we'll use this opportunity to actually hand over these certificates. There are 4 certificates here. I know that, 2 of the colleagues are not here, but I'll start with the colleagues that are here, but I'll actually mention all of them. First certificate goes to Professor Msakati for the granting of a patent entitled Membranes for Membrane Desalination Technology. Prof. Msakati. Prof, I want to do this. I want to do this here. Thank you so much, Prof. The next one is Professor Lucas Neyman for invention entitled Thermal Energy to Electrical Energy Extraction System. Prof, congratulations. And I've been told that we can also hand over this one. This one is also, for a similar invention, for the same invention that we handed over for certificate to Professor Msakati, which is Professor Mapunda, right? But he's not here, but Professor Msakati is going to accept, the certificate on his behalf. Colleagues, the last one goes to Professor Peggy Mamba, is the Executive Dean of the College of Science, Engineering and Technology. Unfortunately, he's held up, elsewhere, so we'll send this off to, to him after this session. Colleagues, I think this is important. And now I need to hand over. My job is done, right?
To honor today's theme, we have a performance by Dr. Evans Neshivambe. Doctor, you may proceed through to the stage so we can hear it.
young generation that is very rebellious. The kids, they beat their parents, they beat their teachers. So it's a warning song, basically. Right. So I'll play it and I'll sing it then. Vateteresi oyiho avateteresi na oyiho 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 uwa uwa oyiho uwa oyiho 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 bana bazilona avateteresi nandedi uwa. I don't want to stand between you and your lunch, so I'll only play one item.
Thank you, Dr. Nechivandwe, for that melodic sound. Mr. Noma, may you kindly come forward to come and close for us. Oh, okay. Dr. Pia.
Thank you again, my sister. Before I do my little task of giving the closing remarks, I think we owe a very big round of applause to our panelists and our facilitator. Can you just give them that applause? Thank you. It gives me time also to gather my thoughts too. Colleagues, we've had a very fruitful day today, and it was very eye-opening for some of us who are not in the arts industry, but more importantly, on a subject that is a livelihood of the African continent, which is the arts, music, and IP. We've learned a lot. I always try to avoid summarizing people's speeches because once I do that, I reduce them to a point where I understood, but there's more to what they said. But I was very glad that Professor Sunet Geya, when you gave us those 10 things that we need to know about music copyrights, and I think someone commented to say it was a lecture on its own in just a few minutes, and you summarize the entire very broad space of copyrights and music in a very short speech, and that was very good for me. As I said, something that you said, which was I think point number 7 or 8, that copyrights subsists automatically, and you even said you cannot register copyrights in South Africa. I'm a bit, a bit confused by that, but as we start to unpack it, especially on that we need to, if you have an artist, you need to copyright your artist, and sorry, you need to register your copyrights, so that you can be able to claim your royalties accordingly. And I think that was very good unpacking of those 10 things in the copyrights aspect, because I initially thought I didn't understand, but as you start to unpack that, so we need to be able to raise our copyrights as musicians. Unfortunately, in a stage where we're now dealing with too many things, one of those is the streaming of our music, and I think Dr. Leroux was able to bring us to the current situation that we're sitting with, where musicians are faced with their music being streamed. So little of the revenues go to the artists. I was shocked to hear that there's so much taken away by the streaming sites, and I think we've got to start to be creative as artists, as lawmakers, as policy makers, to make sure that we protect our artists. We cannot afford a case whereby people are stealing artists' rights and people are taking away from artists and using for their own. And I think it became even much more clearer when we're talking about AI, that much as we've got to embrace these technologies that are here, but ethical use of them is more important. You cannot enrich yourself on other people's efforts and knowledge. So we've got to be able to, as we embrace these technologies, but they must be done in an ethical manner by those that are able to capture them and create more revenues, meaning that artists in a continent, let's talk to AI. Let's let AI be what you're trying to do, but AI creators and those that write these algorithms, bring our musicians on board, make sure that you are able to capture. I think that was what came out from the discussion between Dr. Evans and Spembele, that musicians must embrace these technologies, but also those that use us too must make sure that we use them ethically, because they're here to stay, and the future of all industries is now reliant on the new and upcoming technologies such as AI. Policy is key, and I was happy to hear that in the future discussions, we need to bring policymakers in these discussions so they know that they need to be part of the developments. We can't have policies that come much later when technologies are moving ahead. So those are some of the notes that I captured from our speakers and from our panelists. And thank you very much to Dumelo, who drove the facilitation of all of these. As a unit, as a directorate, DITTC, we are very happy to have you and also those that are online via the Zoom and Teams. We are hoping that in future discussions that we'll be holding, we'll have as many people attending to some of this. In June, I think we will be having another session which will be led by Dr. McLean Sibanda. We will invite you accordingly, and there's many of these, because we believe that the more we talk about technologies developing in our continent, and the more we engage with you who are knowledgeable about the subject, we are on the other side, and you are the practitioners of this knowledge. You are the lawyers in this space, you're the lawmakers, you're the researchers. We want to bring all that dialogue into what we're trying to create, which is making sure that technology is a driver to our economies. And more importantly now, lastly, to thank our musician, our brother, Dr. Chengepe. Oh, sorry, Nechivan, sorry, for Nechivambe, for bringing us a music item. For me, I like music. It's my core thing when I'm sitting alone, and it's good to see that your musical item, it will be recorded one day so we can get it, not only just here, but it will be captured. And make sure that those that are sitting in AIs just don't capture it, and tomorrow you see it on the radio. On that note, colleagues, I would like to, I'm informed that there is lunch outside, which is prepared for you. Please do not go. But more importantly, lunch is about networking. Let's talk to each other, let's share our ideas, and let's make sure that musicians talk to technology developers, talk to lawyers, talk to researchers, and we create an ecosystem so that those ecosystems are what drives Africa's economy. And especially, Africa is not always ahead of these things, and we know we create more than the rest of the world, but we're always behind when it comes to benefiting from this. So let's take the knowledge and make sure this benefits our continent. On that, thank you very much, and a round of applause for your own selves. Let's go.
Thank you so much, Dr. Sia. One small request from to the audience. We would like to take a group picture before we could have our lunch. That would be very appreciated from your side. Just outside by the banners. Thank you. Thank you.